Hello, everyone. Welcome to Jamaica 411. Thank you so much for stopping by, keeping me company as usual. If you're here with me for the first time, welcome, welcome. Please remember to subscribe, share the video, give the video a thumbs up if you find the contents informative, as well as feel free to leave your comments in the comments section. To my subscribers, welcome back. Always nice to have you. Yes, indeed. And you know the ropes, right? You're going to give the video a thumbs up from now, share, then you return. And of course, I thank you in advance. So, you must be wondering what I'm bringing for you today. Well, let me first of all welcome you back and thank you for sharing and liking. And now it's time for us to get down to business. So, what am I going to bring you today? You guessed it. Yes, it is the ruling of the Honorable Miss Althea Jarrett. She's a judge in the case. Yes, and it is the Andrew Holness with his 3 companies versus Craig Beresford, who is the Integrity Commission's Director of Information and Complaints. He's the first respondent. Second respondent is Kevon Stevenson, the Director of Investigations. And the third respondent is the Integrity Commission itself. Yes. And of course, the lawyers are there. Mr. Ransford Braham, Mrs. Georgia Gibson Henlin, Mr. Seon Hanson, Miss Stephanie Williams, Mr. Lemar Neal, and Mr. Vashini Headlam. And they are instructed by Gibson Henlin. Those are the attorneys for Mr. Holness. Yes, sir, one heap of them. But of course, the Integrity Commission was not going to be outlawed. So them come with a heap of lawyer too. Mr. Michael Hilton, I guess he would have been the one who is the lead attorney. Mr. Kevin Powell, Sundiata Gibbs, and Anne Wheatle, instructed by Hilton Powell for the respondents. That would be Beresford, Stevenson, and the Integrity Commission. Now, of course, the hearing was on the November 7 and 8, 2024, and December 6, 2024, when the judge made her ruling known to us. So the judge is giving us a little summary, if you may call it that, of what her judgment entails and what it is that she was required to do. So there's an application, of course, for leave for judicial review, whether the threshold test for the leave was met. That is what she has to decide. Whether special report of the Integrity Commission amenable to judicial review, whether orders of mandamus can lie, the Integrity Commission Act, the Corruption Prevention Act. Those are the 2 acts that she'll be looking at that would help her in her making her decision as to whether or not to allow the application for judicial review made by the Prime Minister. Okay. So the matter was heard in chambers, which means not in open court. And the judge, of course, is Justice Althea Jarrett. And in her introduction, she said, the primary question before the court is whether the applicants should be granted leave to bring a judicial review claim against the respondents to challenge the following reports. Of course, the applicants is Andrew Holness and the companies, and the respondents would be Craig Beresford, Stevenson, and the Integrity Commission. So it says here there's a challenge to the following reports, and this would be the investigation report into the statutory declaration submitted by the Most Honorable Mr. Andrew Holness, Prime Minister for the years 2019 to 2022, in respect of concerns that he owns assets disproportionate to his lawful earnings and that he made false statements in his declaration by way of omissions, contrary to law, and that report was dated August 30, 2024, and there was attached an addendum dated September 9, 2024. You will recall that that addendum was an additional witness statement from one of the persons who were employed to NCB, if my memory serves me correct. The second challenge is to the special report submitted by the Integrity Commission under Section 36(3) of the Integrity Commission Act in the matter of an investigation report of an investigation conducted into the statutory declaration submitted by the Most Honorable Mr. Andrew Holness, Prime Minister, for the years 2019 to 2022 in respect of concerns that he owns assets disproportionate to his lawful earnings and that he made false statements in his statutory declarations by way of omissions contrary to law. And that special report was dated September 5, 2024. You recall the special report was that one where it was Greg Christie who signed it, I suppose, on behalf of the commissioner, the chairman, Mr. Seymour Panton, where they were encouraging the Parliament to forward the report, the investigation report, to the FID so that they can commence their investigations. And according to the special report, unless that is done, the statutory declarations for 2021, 2022, and 2023 will not be certified. That the feisty piece of letter, yes. So that is also up for judicial review. At least the Prime Minister is hoping, to get the court to agree to allow it to be reviewed. So at 2, Milady went on to say, yes, that's how we style our judges, Milady, the female ones at any rate. So anyway, she went on to say at 2, paragraph 2, the judicial review remedies for which the applicants, which is Holness and the companies, seek leave, and leave means permission, are orders of certiorari to quash the aforementioned reports, orders of mandamus compelling the first respondent, Beresford, to examine the 2022 and 2023 statutory declarations of the first applicant, Holness, as provided by Sections 32 and 42(1) of the Integrity Commission Act, to comply with Sections 32 and 42(1) of the Integrity Commission Act in relation to the first applicant's statutory declarations for 2021 and 2022, and compelling the second respondent, which is the investigator, to recommend to the third respondent, the commission, that the first applicant, Holness, be exonerated in relation to his 2021 and 2022 statutory declarations in such a manner as the third respondent deems fit, in accordance with Section 54(5) of the Integrity Commission Act. There are, however, several other remedies being sought by the applicants, which are not judicial review remedies and therefore do not require the leave of the court to bring a claim. I will come to these later in this judgment. So, what is happening here now? So, Holness is asking for judicial review in order to quash the decisions that were made by the investigator in his investigative report, as well as to quash this referral that they have made through the special report, or requested that the report should now be sent to the FID, right? The effect of it will be to delay the completion of the investigation, so that Holness's statutory declarations would either be certified or not. And what is strange, just as an aside, is that it does not seem to concern the members of the Integrity Commission, that is the effect of what they are doing, right? Because if they were concerned and they realized they were in a spot, they should have at that time sent the report and the information that they had, or ask the FID to assist them in some way in investigating the things that they wanted investigated. They didn't do that. They deliberately waited. It has to be deliberate. They waited until the end and say, you know what? Let's send this to the FID. But we're not going to send it now. We're going to send it now to them when we do the report and table it in Parliament. That's the time when they are asking for it to be sent to the FID, which would have the effect of them. Remember, the Integrity Commission has been investigating for about 3 years, So you imagine. No, seriously, this is a very serious matter. Anyhow, we're not onto that today. We just brought that up as it came to our minds. But that was what the judicial review is about, to quash the report, because you can't have them reversing their decision. The law says that if you have an issue, then you are to seek judicial review. So those two. Now, the order of mandamus now is to compel the Beresford. He is the Director of Information and Complaints, and he was the one who would have received the statutory declarations, and he's the one who would have examined them and sent them forward to the commission, if all is well, to be certified. If all is not well, then he would refer the statutory declaration to the commission, asking them to refer the matter to the investigator to investigate whatever it is that he believes is requiring of investigation. And that was what happened in Holness's case. When the referral gets to the investigator, he then commences his investigation into the matter. Now, what Holness is asking the court to do by way of an order is to order the Director of Information and Complaints to examine his 2022 and 2023 statutory declarations. That is because, if you recall, in Andrew Holness's affidavit, he said they had written to Beresford and asked him about the 2022 and 2023 declarations that Holness submitted, and he said he had not examined them yet, right? So when this application was put before the court asking for Beresford to examine those reports, it was because they were under the impression, based on what he said, that he had not done it yet. So by the time the case came up, right, and he came to give his evidence, he told the court, oh, I have examined them. So there is no need now to proceed with him any further, because he said he'd done what he was supposed to do. So he must have done it sometime before or after the matter was brought before the court by Holness. Good. Now, if the only conclusion I can come to here, think about this now, is that if he had examined them, right, and never reported it to Holness and his attorneys that he has examined them, it meant that there was no issues with those two. That's the only conclusion I can come to. Because if there were issues and if they were not complete, then he would have called in Holness and asked him to furnish further information. I wonder if you see where my logics is going. Yes, man, that is what me think I go on this up, but make us set that aside. So the most important point is that at the time when the case was brought, Holness and his attorney was not under the impression that the two reports were examined. Otherwise, I wouldn't ask for the court to compel him to go and examine them, right? So that matter was settled. There was no need for the judge to make any pronouncements on that, other than to say that the man said him examine them, and so they right there. So now everything all right. That's all. At 3 now, it says here, the first applicant, Andrew Holness, is the Prime Minister of Jamaica. The second applicant, Imperium Investments Holdings, is a limited liability company registered in Jamaica, of which the Prime Minister is the sole director and shareholder. The third applicant, Positive Media Solutions Limited, is also a limited liability company, of which the Prime Minister is one of two shareholders, and the fourth applicant, Positive Jamaica Foundation Limited, is a company limited by guarantee incorporated by the Prime Minister. On the respondent's side, the first respondent, Craig Beresford, is the Director of Information and Complaints at the Integrity Commission. The Integrity Commission is the third respondent, and the second respondent, Kevon Stevenson, is the Director of Investigation at the Integrity Commission. So what the judge did there was to say who the parties in the matter are. Okay? She went on to say, I am aware that given the issues raised in the impugned reports, the remedies sought in the application, and the parties involved, this matter has attracted tremendous public interest and attention. True. In this judgment, therefore, I believe it is important to first examine judicial review and to explain what this very nuanced but extremely important public law proceeding is and what it is not. So, Milady has kindly consented to explain to us what the judicial review means because she knows that we will be reading it today. So, let's see what she says. Now, in terms of the law, she says at 5, simply put, judicial review is the process by which the Supreme Court exercises its supervisory jurisdiction over the decisions, in quotation, of public bodies, inferior tribunals, and public officers. So she's saying this is about government, not about private citizens. You can only get a judicial review if the matter concerns a government entity, such as a public body, statutory body, anything to do with government and the exercise of their authority. Then if you feel yourself wronged, it is through the process of a judicial review that you will seek redress, remedy, or your rights. Yes, ma'am. All right, so let us continue. In exercising its jurisdiction, however, the court is not concerned about the merits of the decision, and this is the decision of the public body now and the public officers, or whether it is correct, but whether it is legal and the decision-making process fair. In other words, it's not about the ethics or the morality of the decision that was made. It's not whether or not it's right or wrong. What is important is whether or not it was legal, meaning that the government set up these companies and these bodies to carry out certain functions, and they are given laws and regulations by which they must exercise their public powers. And so what the judge is saying that in a judicial review, what they look at is not whether the law is right or wrong. That's not the point. They're not looking at that. What they're looking at is whether the public officer decision that they made, right, is according to the law or not. That is what it is saying here. And whether or not the process was fair. So if, for example, the process said that before you take a certain decision, you must call the person in and give them a fair hearing. But you went ahead and did everything the law says you were to do except to call them in and give them a hearing. In that case, the process was not fair and the judicial review can be requested in order to quash that decision. You following? Great. So let me continue. So Milady went on to say, in performing its role, the court cannot usurp the decision-making power granted to the public body, tribunal, or officer by Parliament through legislation. So, what she's saying, we went and we elected members to the House, the Prime Minister and the Leader of the Opposition. They then recommend for appointment the senators. When them sit down together and they make a law, it is not for the judge to go question them law unless it is in breach of the Constitution. Outside of that, if they make a law and the public officer carries out that law in relation to their jobs, the court has no power to compel them and tell them how they must carry out that function if the law is the one that gives them that power. You follow? That's what that is saying. Milady said, put another way, it is not for the court to make the decisions which the public body, tribunal, or officer alone is empowered to make within the parameters of the legislation from which a power or a discretion is given. You follow that? Right. It will be immediately clear, therefore, that judicial review is not an appeal from the decision of a public body, tribunal, or officer. In other words, so you have business to do with one of the public bodies. They made a decision, you felt it was unjust. You cannot go to the courts on a judicial review and ask them to overturn the decision that was made as a form of an appeal, right? No, the judicial review is only about whether or not they acted within the law or the process that they were supposed to follow, then follow it. That's what that is. So an appeal, they're saying, is different from a judicial review. So let the judge explain herself, which she is quite capable of doing. So Justice Brooks now, the former head of the Court of Appeal, he made a ruling in a case, and the judge is going to use that case as a means of backing up her arguments that she is making. Because them have to back up them argument too, otherwise them lawyer, they will just appeal. And if the judge's decisions shaky on any point, them can win them case. Yes, man, that's how it works. So at paragraph 6, the judge referred to now Brooks, Justice Brooks, as he then was, captured the distinction well in Industrial Disputes Tribunal versus University of Technology and the University and Allied Workers Union, consolidated with the University and Allied Workers Union versus the University of Technology and the Industrial Disputes Tribunal. What a long case. And of course, the decision was delivered in that matter on October 12, 2012, which is a recent case, at paragraph 24 of his judgment. So, milady is now quoting what he said in that case. A basic but accurate distinction has been set out in the Caribbean Civil Court Practice 2011. The learned editions at page 431 state, judicial review of an administrative act is distinct from an appeal. The former is concerned with the lawfulness rather than with the merits of the decision in question, with the jurisdiction of the decision maker, that is a person in the public body that made the decision, and the fairness of the decision-making process rather than its correctness. So there it is. They're emphasizing again that the judicial review is not about an appeal. It's about whether or not the decision that was taken at the public body level, whether it was according to the powers that was given to them by the Parliament, and whether the process that they followed was according to the process that they should follow and given to them, again, by the regulations of the Parliament. See what I mean? Great. So now we continue with milady now. She said, in Administrative Law 10th edition, Wade and Forsyth state the principles a little differently, but with no less merit. At pages 28 to 29 of their work, and they're quoting now, The system of judicial review is radically different from the system of appeals. When hearing an appeal, the court is concerned with the merits of a decision. Is it correct? When subjecting some administrative act or order to judicial review, the court is concerned with its legality. Is it within the limits of the powers granted? So there you are. Again, they are trying to explain to us so we can understand. Yes, ma'am. On an appeal, the question is right or wrong. On review, the question is lawful or unlawful. So that's the clarity. At 7 now, they said that the scope of judicial review was set out in Council of Civil Service Unions versus Ministry of Civil Service of 1985. That's the decision-making date, I do believe. Lord Roskill, in dealing with its evolution, said at page 414 that executive action will be the subject of judicial review on 3 separate grounds. The first is where the authority concerned has been guilty of an error of law in its actions, as for example, purporting to exercise a power which in law it does not possess. So the Constitution gives the government certain powers, and where it is silent, the government does not have that power. So if the government gone in at the parliament gonna make some law claiming that them have this power to make this law, and they do not, then that law can be subject to a judicial review, where they will look at it and find that it is unconstitutional, and where the court does, that will be end of that. So let me continue now to the second grounds. So the second is where it exercises, this is the executive action now, where it exercises a power in so unreasonable a manner that the exercise becomes open to review upon what are called, in lawyers' shorthand, Wensbury principles, and them tell you if we go check out one law. The third is where it has acted contrary to what are often called principles of natural justice. At paragraph 8, she said Lord Diplock, in that same decision, classified the heads of judicial review as illegality, irrationality, and procedural impropriety. In respect of irrationality, he said at page 410 that by irrationality I mean what can by now be succinctly referred to as Wensbury unreasonableness. It applies to a decision which is so outrageous in its defiance of logic or of accepted moral standards that no sensible person who had applied his mind to the question to be decided could have arrived at it. My goodness. That's something that sounds really rational for true. Not true, my peeps? So, my lady went on to say in her discussion of the matter of judicial review and the fact that it is not an appeal, she went on to say, our Court of Appeal in Office of Utilities Regulation versus the Ministry of Industry, Commerce and Technology said that the courts will not usually regard a decision of a public body as so unreasonable regarding quashing unless the decision is regarded as reaching the level of absurdity. Well, me can't even give you an example of that, but if you know of an example, you can leave it in the comment section. All right, me peeps? Let us move along. But what they're saying is, based on the court's decision, they're not just going to quash a decision made by a public body unless it can be manifestly shown to be absurd, ridiculous is basically what they're saying there. So now she's dealing with the need for leave. She's going to explain now to us why Mr. Holness and others who seek judicial review needs to get permission from the court. So at paragraph 9, my lady said, Judicial review is a two-staged process which requires an applicant to first get the court's leave or permission to bring a judicial review claim. Justice Mangatal, as she was then, in Honorable Shirley Tyndall OJ, Patrick Hilton, Omar Davies, Jamaica Redevelopment Foundation Incorporated versus the Honorable Justice Boyd Carey, Charles Ross, and Warwick Bogle. They were the commissioners on the FinSAC inquiry. Remember them? Yes. So apparently Omar and the others were challenging them about something. Anyway, the decision was delivered on February 12, 2010, addressed the need for the court's leave at paragraph 8. So again, the judge is going to justify her arguments. She went on to quote from it, that particular case. Unlike public law remedies, there was and is no requirement generally for persons pursuing private law rights against other parties to obtain the leave of the court before starting a claim in court. In other words, if I go and sue somebody or somebody go and sue me, they don't have to apply for leave. They're just putting them claim in the court. They don't have to ask the court's permission. That's what that is saying. It is difficult to improve on the description of the purpose of the requirement of leave set out in the well-known decision of the English House of Lords in Inland Revenue Commissioners versus National Federation of Self-Employed and Small Businesses Limited, where at pages 12 to 13, Lord Wilberforce stated, the need for leave to start proceedings for remedies in public law is not new. It applied previously to applications for prerogative orders, though not to civil actions for injunctions or declarations. Its purpose is to prevent the time of the court being wasted by busybodies with misguided or trivial complaints of administrative error, and to remove the uncertainty in which public officers and authorities might be left whether they could safely proceed with administrative action while proceedings for judicial review of it were actually pending, even though misconceived. You have some people with money, you see, and all they want to do is go into the court, go waste the court time to make themselves look important. So what this is saying, why you have a two-stage requirement in the judicial review as opposed to when you're suing somebody or somebody suing you, or people suing them one another. There's no two-stage in that. You have a problem, you carry them to court, you submit your document, and then give you a hearing date. In the judicial review, it's different. Why? Because they must have found that a lot of people were carrying even private matters and asking for judicial review when it's only cases to do with public decisions that are made by public bodies and laws passed by the parliament and all them something there. So what they're doing is vetting the applications that are coming to them to make sure that the only ones are sent forward for judicial review are those that are supposed to be sent forward for judicial review, which are, as I said, concerning decisions made by government people. So what I mean? Good. I heard you. Yes, man. All of my peeps them bright enough, because I know you say, Michelle, me get it long time. Get on with it, man. All right. Well, we have to get through the foundation. She'll lay her foundation, that when she come liquid with some arguments later, we can understand what it is she's saying and why she made that decision. So now she's on to know the test of that leave. And this is at paragraph 10. And this is now where we're getting down to business. Yes, man. There is, however, a threshold test to obtain leave, which every applicant must meet. The burden is that of the applicant to show that he, she, or it, if it's a company, has an arguable case with a realistic prospect of success. What all that mean? Well, Let's continue and we'll see if she explains. Referring to this test, Justice Mangatal at paragraph 10 of her judgment in Shirley, the Honorable Shirley Tyndall OJ, that's the same case with Omar Davies, quoted from the dictum of Lord Bingham of Cornhill and Lord Walker of Westinghope in Sharma versus Antoine Brown in 2006. And they said that this case was an appeal to the Privy Council from the Trinidad and Tobago Court of Appeal. And Justice Bangatol said, in Sharma versus Brown Antoine, a decision of the Judicial Committee of the Privy Council in relation to our Caribbean neighbor Trinidad and Tobago at paragraph 387, Lord Bingham of Cornhill and Lord Walker of Westinghope indicated, and she's quoting them now, the ordinary rule now is that the court will refuse leave to claim judicial review unless satisfied that there is an arguable ground for judicial review having a realistic prospect of success and not subject to a discretionary bar such as delay or an alternative remedy. And then he referred to a case which is Regina versus Legal Aid Board, ex parte Hughes, and that case concluding in 1992, and give you all the various references as to where you can find that law, that case law. But arguability cannot be argued without reference to the nature and gravity of the issue to be argued. It is a test which is flexible in its application. So what it is that the lords were saying in this part here now, that one of the tests of whether or not they are going to grant the permission for your case to go forward to judicial review is that you must have a case that can be argued. You must have something that happened, right? And that would be the decision made by the public body or the public officer. Then now you have to be able to present a case of, the issues that surrounding the decision that you want to have reviewed. Is the decision you want to have reviewed, right? And so you have to come with your arguments, which will entail all that happened. And then now you have to demonstrate to the court that you have a realistic prospect of success, meaning you have a realistic chance of winning the case. So my peeps, you see now that we're really down to where we need to be. Yes, this is the real test that Master Andrew had to pass before he could get the court to agree to grant him permission to have his matter reviewed by the courts. So, Milady went on, though, in quoting from Justice Mangatal's decision. Continuing, she said at paragraph 11 of the judgment of Mangatal, and she's quoting again, it is to be noted that an arguable ground with a realistic prospect of success is not the same thing as an arguable ground with a good prospect of success. The ground must not be fanciful or frivolous. A ground with a real prospect of success is not the same thing as a ground with a real likelihood of success. The court is not required to go into the matter in great depth, though it must ensure that there are grounds and evidence that exhibit this real prospect of success. So what does that mean? It means the only way that you can show that you have a realistic prospect of success, you must first establish that you have grounds for requesting the review, and secondly, you must be able to back up those grounds with evidence. You follow? So every step of the way, you said these are the grounds, and you must show and exhibit your evidence to support that. Otherwise, the judge is not going to accept the grounds that you brought and fling that out. We will find out soon enough if any grounds that the Prime Minister brought was backed up by evidence or whether it was accepted for judicial review by the court. But let us continue at 12. It says, in arguments before me, so that the judge now getting down to the meat of it. In arguments before me, it was submitted by Mr. Ransford Braham, KC, counsel for the applicants, that's Holness and the companies, that the modern approach to the test now includes taking into consideration the public interest. The court will generally grant leave where the case raises questions of public interest, and that in this case I ought to do just that. For this proposition, King's Counsel relied on the Privy Council decision of Attorney General of Trinidad and Tobago versus Ayers Caesar 2019 and the English Court of Appeal decision of Regina Gentle and Anor versus Prime Minister and others. That's what Anor mean, I think, others, 2007. After reviewing these two decisions, so she said, so Ransford come and say, Judge, them the things that were used to go on all time things, they have some new approaches, what them are going with now, and him quoted two cases. So the judge said, all right, I go read them. So when she went and read them now, she's coming back to tell him and us what her findings were that the cases were about. So she said, after reviewing these two decisions, I am not persuaded that they reflect a modern approach to the test for leave for a judicial review, and that if a case raises questions of public interest, leave should be granted on this basis alone. Can you imagine? We said them lawyers can go on with things, The judge couldn't believe with her ears, so she decided to go read it herself, only to find that not go so like what you must say, right? You can't just simply talk about because the public, this is a prime minister and the public is interested, as in the case that, he mentioned. Because it's the prime minister and the people are interested in it, you should allow the judicial review, regardless of whether there is evidence to back up what it is that, you are you're asking for a review for. Lot of mercy. Anyhow, so of course, she kind of push that aside. So at paragraph 30 now, she's quoting from the other case that was mentioned by Braham. Attorney General of Trinidad and Tobago versus Ayers Caesar concerned an appeal by the President of Trinidad and Tobago from the decision of the Court of Appeal in which the majority refused his appeal from the first instance court's grant of leave to a High Court judge to bring a judicial review claim against him for the refusal to set aside her resignation and to reinstate her. The respondent's case was that her resignation had been procured by unlawful pressure and duress placed on her by the Chief Justice, and therefore Section 142 of the Trinidad and Tobago Constitution dealing with resignations from office did not apply. In refusing the appeal, the majority of the Court of Appeal found that it was arguable that Section 142 of the Constitution does not apply to an invalid resignation. They also considered that it was in the public interest to allow a judicial review claim against the President, since the issues raised affected not only the parties but the general public. When the matter came before the Privy Council, Lord Sales, writing for the majority, cited the board's earlier decision in Sharma and stated unequivocally at paragraph 2 that, and she's quoting them now, the test to be applied is the usual test for the grant of leave for judicial review. The threshold for the grant of leave is low. The board is concerned only to examine whether the respondent has an arguable ground for judicial review which has a realistic prospect for success. Wider questions of public interest may have some bearing on whether leave should be granted, but the board considers that if a court were confident at the leave stage that the legal position was entirely clear and to the effect that the claim could not succeed, it would usually be appropriate for the court to dispose of the matter at that stage. So, what is it that they are saying here? The attorney for Andrew Holness brought up the matter of public interest as one of the bases for allowing a judicial review. And he quoted a case, and the judge has to deal with the case to see whether or not public interest would be one of the factors that could be considered in determining whether the case should go for judicial review. And what she's saying that the Privy Council found was that, yes, maybe you might want to consider, the wider public's opinion on the matter. But if when the judge look on the case, the judge say that the law is clear and therefore there is no need for a judicial review in that case, then it should terminate. In other words, the public interest is not what is to be used to determine whether a case go forward, but whether or not there is grounds or there are grounds that were established by the applicant, in this case it will be Andrew Holness, and whether or not he has presented his evidence to back up those grounds that he has laid down, and thirdly, whether or not he has a realistic prospect of success. So we're going to take a break now. We're going to go and have a bite to eat. And for those of you who need to stretch your legs, feel free to stretch your legs, and then we'll return. When we return, we will pick up again at paragraph 15. So I hope you found this section very interesting. The judge has laid out very nicely for us what the judicial review is and what you need to do to get their permission to send your case to judicial review. So I'll catch you guys later.